going to look at contract issues during this time of crisis and focus on three areas. One is sort of the main contract challenges that have been thrown up by COVID-19, some immediate and medium-term steps that everyone should be thinking about, and then I'll have a quick canter through force majeure. So in terms of what the key contract challenges are, they're really throwing up two competing challenges. First, customers' requirements in terms of volume and service, along with their ability to pay, is fluctuating significantly. Some customers' requirements have shot through the roof, and others are trying to ramp them back significantly. So the second competing one is that suppliers are struggling or can be struggling to perform the contract because they may have staff disruption and they may have their own supply chain and cash flow issues. So in terms of what we're seeing in the supply chain ecosystem, I think as we all know all too well, the pandemic has required huge amounts of shifts to remote working, and this has had a profound change on outsourcing providers around the world. And perhaps the starkest example of that is the Indian government's 21-day lockdown of its entire 1.3 billion population, which is causing huge logistical complexities for delivery centres across the country. Related to that is a sort of very fast moving point which varies from jurisdiction to jurisdiction, which is where essential services are being identified and defined by governments in each location. And the Indian government has been supportive of the IT industry in this relation. So whilst the focus of attention has been initially around the physical and logical layers of security to protect customer data, the sea change of delivery is also raising a number of other concerns and considerations for customers and service providers. Obviously, security aspects are absolutely key, and I know that Matthew's going to come on and talk about those in fairly graphic and scary detail later on. But in terms of looking at contracts, it's important to ensure that work from home arrangements will meet current contractual requirements or that appropriate variations are made. And there's also a need to look at any sector-specific regulatory regimes that businesses may operate in. There is a small chink of light, I think, perhaps in that this is no doubt going to be an inflection point for the industry and could serve to look at different more flexible models moving forward, and also will no doubt speed the move to automation. So what are we seeing in terms of market? What are we seeing in the market in terms of contract challenges? Well, we've seen parties to outsourcing contracts really focus on the following. First of all, they've tried to work out what are their critical services, are any of those required for regulatory purposes? If so, can the supplier be permitted to focus its available resource to those areas, or for the supplier to do on a location by location basis to support any mission critical service delivery? And it's important to bear in mind that jurisdictional requirements there in terms of essential services. The critical stand, looking at what your critical.
Tom, I think maybe you could turn your video off because the connection's not strong enough at the moment.
I will stop the video.
Yeah, thank you.
Is that better?
Yes.
Is that better?
Yeah.
Okay, so we were saying that it's key to look at critical and then look on a location by location basis, and then essential and working out whether you can still get services to perform that. And in terms of then looking at priorities, it's also important to keep a firm eye on what your contractual obligations and so similarly, the service providers are also trying to work out what the customer's most pressing needs are, and I think it's important for service providers to be pretty frank and open about this. And then that means that there can be then a discussion around service levels and KPIs and appropriate adjustments made. And if suppliers are struggling, then in some cases customers are potentially able to provide their own additional resources, whether that network capacity or kit, and make that available. So and potentially bring some IT in-house on a temporary basis. And the other area that's obviously area to look at the pricing mechanisms which are often designed for business as usual, they clearly need to be reassessed during this time. In terms of kind of immediate and medium terms that we are seeing people do, can we have the next slide, please, Debbie? And I think there's one after that, please. Oh, yeah, that one. Thanks. So I think the first thing is absolutely key is collaboration, absolutely critical. Service providers and customers, first and foremost, to be working collaboratively. Going to come on and talk a little bit about that later. So obviously there may be circumstances, and that's when you may need to more closely at your contract. First instance, on ongoing dialogue and a flat approach is key. So it's important, whilst doing that, also not to lose sight of contractual remedies, and I will talk later on about force majeure. Although I think in the first instance, finger pointing and making threats to terminate will cause more harm. The second thing to do is to make sure that you document any changes. If the service provider is seeking a waiver of contractual requirements or the customer's reprioritizing, then it's very sensible to make sure that these are properly recorded. A change control procedure, then you should follow it, and also you need to be following any gun escalation procedures. It's important, I think, that all the internal concerns should process and appropriate stakeholders, whether that's security, information security, compliance, audit, and so forth, are all appropriately involved in these processes. I think it's also possible to be aware of what we call the externalities, what's going on in the out world. So if you're moving to a work from home platform, does that impact your liability insurance coverage? Does that have an impact on audit and any particular obligations to comply with Sarbanes-Oxley in the US? And the other area, external area, obviously to be important is to be aware of is what are your regulators saying, and we're helping a number of trying to work their way through that particular area at the moment. The fifth point to make is that you got to move on with this, obviously, but you've got to balance the need to fast with the need to make sure that what you do is appropriately considered and the right thing. So there's a real balance there. And then finally, the area that a lot of people are now looking at quite closely is business continuity planning. I think a lot of our clients and their suppliers or customers are finding that had very detailed business continuity plans which did not cater for a global down of business and people self-isolating. So there's been a huge amount of work done with a lot of people that we're working with around their BCP plans. And I think the key lessons from BCP plans are make you understand where your single points of failure are, whether that's with an employee that might potentially be hospitalized or whether you've got a key vendor, and you need a decent team of BCP on your BCP. So with a decent team of appropriate experts who can think strategically, but also implement, who can challenge the conventional views of what's probable, do appropriate drill downs on what your planning is, and where appropriate, do post-mortems. So I think BCP is a real area of focus these days. I'll just come on the final piece now, just to talk about force majeure. I know collaboration is key, but it isn't, I think, just to keep an eye on what your rights and obligations are under the contract. And interestingly, you've been invited as a firm with questions about force majeure. Everyone wondering how force majeure works, and in fact, for some clients with huge volumes, we are operating a triage service to help them work through the huge quantities of contract reviews that are needed. So the first thing to note on force majeure is that, unlike in many civil law jurisdictions, there's no implied application of force majeure under English law. So you will only be able to get relief under force majeure if your contract has an force majeure clause, and it will therefore depend what your contract says. So it is therefore a job to be done, therefore a job to be done to individually analyse each contract and what each force majeure clauses say. Once, assuming you've force majeure clause, that's the first hurdle. Then you need to work out whether what's happening is within the definition. Some force majeure clauses will have epidemic or pandemic called out, and the World Health Organization declared that COVID-19 is a pandemic, and they declared that on the 11th of March. So in a lot of being part. The second thing, though, is once worked out whether the definition, you then need to work out, there needs to be a causal link between the definition and that prevention before operation. So to be able to show that the only reason you can't perform is because of that force majeure as defined. The requirement to mitigate all reasonable steps to mitigate, and then finally you will usually have fairly detailed notice provisions in the contract setting out so sometimes within a certain time period you've got to notify the counterparty within, say, 7 days or 21 days. It sometimes requires further information, like how are you going to address the force majeure, what steps are you taking to bring things back online, what are your mitigation steps, and also sometimes there's a requirement to do regular updates. So it's important to make sure that you follow the rules and that you follow the notice requirements in the contract to ensure that you give notice in the appropriate way. Risk of claiming force majeure incorrectly. If you claim force majeure when you were not entitled to do so, that could put yourself in breach of contract. So it's important to follow the rules and understand what your rights and obligations are under force majeure. As I said, it varies from country to country, and we have developed, which is on our coronavirus website hub. We've developed a guide in setting out the 32 different countries.
Tom, question.
Yes, hi.
How, without going into specifics or disclosing anything confidential, how many clients have actually, as a rough percentage, actually raised force majeure as a formal process?
We've quite a few. That some where been an obvious, they're obvious and they can't be closed. So that it's much easier to demonstrate that because of homework they've had to close. They've had a hard, but then got to show what mitigate. Others have sort of tried to argue part of a sort of robust discussion with their counterpart. So it's a minority said we want to rely, and most people are going down the collaboration. But we've been a lot of advice background about what the actual obligations are, so people know what the position is on the contract.